In this podcast, we're going to be talking about the Seventh Amendment, continuing on the Bill of Rights series of podcasts. But first, I want to ask people to consider donating to my Patreon page. It's www.patreon.com/challengehistory. And we have tiers of $1, $10, $25, $50, and $100. I would appreciate any donation. It would really help me. I'm currently on disability, and money goes to help me in my personal life as well as to help with the running of the podcast, because currently I'm not getting any ad revenue, and that would really help me with both aspects of it. This would really help on both, so if anything that could be donated would be greatly appreciated. Even just $1 a month would really be appreciated, because it starts to add up as more and more people donate. Now on to the actual video itself. We're going to go back to the Bill of Rights, first of all, reading the thing. And it says, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall otherwise be examined in a court of the United States than according to the rules of common law. So basically, they in anything, they have the right to request that the trial by jury, number one, and then they're basically guaranteed that trial by jury in all cases of values of $20 or more, or I should say exceeding $20. And this is basically over anything that's either over theft or damage of $20 of property. This is very important, because what might have been considered as $20 of lower value at the time this was written, it's now considered a much lower value, which makes this a very important rule because of the way it's written. And $20 is very specific. If you look right here, it does not state at the actual specific thing or any specific value of, it's saying $20. It's not saying $20 of gold at a specific year. It's stating that's $20 in general. And $20 of that specific year would have been completely different in value, as we see, but in comparison is it would be much more in common day, as we know. But the fact is because we take it at its face value when we're reading into this, we understand that we're not reading into the idea of inflation when we're considering the actual constitutional amendments. $20 will mean $20 no matter what year, as they do not consider year by year for the ideas of inflation when considering the actual Constitution, when an actual amount was considered. Thus, they most likely already understood that inflation could exist. When considering that amount, they were probably considering that amount to be considered as stationary, and income levels to be much higher as years went on, so that this level that it would take would actually go down to require a court case for trial by jury, meaning that you weren't just going to be in front of a judge in most cases. It was going to cause where you could actually demand a trial by jury in almost every case. at a certain point, because almost no controversy that we face today would be $20 or less. I mean, it would have to be excessively small. You'd have to be taking something of almost no value for it to be that low, and that would have to be just discussing on the actual damage or theft of property. And that's where we would be going at for it to be not able to be qualifying for a trial by jury. And this is where this becomes very, very beneficial, because a trial by jury gives you the benefit that's the same idea of what the benefit of representation of a Congress over for decisions to go to war, what the same idea what decision to go to war, what an individual would be, is you get essentially very in decisions, it gives you the benefit of multiple people discussing an actual decision on how to judge, and this makes it a lot better in the end, because you're going to get decisions that are going to be usually a lot better thought out, assuming that these people are well instructed and aren't just basically instructed in the way that they get led to either convict or not convict, depending on how they're instructed. They're supposed to be instructed on constitutional stuff. As long as they're instructed constitutionally, they're going to be much better suited than a judge would. And this is why trial by juries are essentially superior to a trial by an actual judge itself. Just having the judge itself, essentially, they could be biased in one way or the other. There's no consultation with anybody else, and this makes it very, very problematic. And that's the whole issue. And that's where we get with this whole thing. That's why this thing is a little bit. That's why this thing becomes very, very important. And people might tend to look over this one, but that's something that's when you get the difference between one person next to a whole jury looking over it, it can really change out the outcome of one event. And third, because you might have a judge look on precedent, or a judge look very, very harshly in one way or the other, whereas a jury might look in a way of, they might look in the aspect of nullification on law. They might look in the aspects of being very, very, they look on the idea of nullification in the way that they're following the Constitution as written, and they might not rule in the way that the state might rule. So it makes it a lot different. It can be a severely different outcome than what's would be expected for what a normal judge that's been appointed or elected might rule. And this is what could be making it a lot different. It doesn't matter if we're talking in the case of what might be in this situation, what might be a lawsuit over property, or if we're talking in criminal prosecutions as what the Sixth Amendment or Fifth Amendment go over, but this is which tend to focus on the criminal prosecutions, but this still goes over the idea of you're guaranteed that trial by jury, and that jury becomes very, very important. and they can rule one of many different ways. They can rule on the favor. They can rule very, very similar to what the judge is stating. They can rule very, very similar to what the defense is saying. They can rule very similar to what the prosecution is saying. They can also rule in the idea of jury nullification and view the Constitution as a supreme ruling. So they have really one of four different ways of ruling, which makes it, or they can rule on some other different way, which could be they can feel some other types of ways, such as some type of social justice way of ruling, which could be another alternative way of ruling on a case. And they could rule on that thing and say that they're going to rule in this way with it, no matter the facts of the crime or the facts of the case. And it can basically cause you're talking at least five different ways of ruling a trial by jury. When you're talking just a judge, is basically the judge is most likely going to either A, side directly with the prosecution, or B, side directly with the defense. They might have an alternative thing of basically going off precedent of the law. So basically they're not going to have much variance in what they're going to do, in how they're going to use it. Very, very rarely does a judge ever have the options of what a jury would do. And usually when a jury does opt for their nullification, they usually tend to become miffed because they don't like when the jury uses nullification and opts for following the Constitution over precedent. And this is where we find some cases where the judge becomes mad at them doing that, and the judge tends to question their decisions. And the judge will ask each individual member how they did vote, what they were thinking when they were voting, and you'll find just things like that. And because the fact is they tend to not look highly upon nullification, yet it is a completely legal way of a jury reacting. And this is something that does happen quite often. It happened in the Bundy case. They felt that the idea of land rights superseded the government overreach, and saying the government had the right to basically take their land. And this is where we saw the outcome of that case, and that was essentially through what became jury nullification. And a lot of these judges do not usually take kindly to outcomes like this, because many judges out there tend to be focusing on the idea of either precedent, which means basically they like to leave the law as is, even though it's not constitutional. And when we see this, you'll see when I get to the idea of the 13th Amendment, which I will probably discuss later on down the road. I'll probably go on that with the on like March 8th or something, and you'll see that I'll discuss that, and that goes into the idea of what happens with the with slavery. Now, if precedent would have existed with slavery, you would understand that that slavery is, if precedent would have existed with that, that makes that a different case. Now, that's something that needs to be understood. Now, this is why when we have trials by jury, why precedent would never be used by a jury, because they would never view precedent as being an issue. They never said you would never see a jury say, well, it's been this way for a long time, so we're just going to leave it as is. A jury would never in a million years state that. That's not how a jury reacts. A jury always reacts with the idea that people react in a way that they say that they feel that they'll either side with agreeing with what the judge is trying to lead them with, what the prosecution is saying, what the defense is saying, or or they tend to go with either some type of social justice point, or they'll go with the idea of what the Constitution directly says, and they'll actually look over the Constitution, or they'll actually take the idea of what they know personally with the Constitution. Sometimes you'll get people in a jury that actually know the Constitution back and forth, and they'll actually understand that the idea of private property rights is actually a natural right, and that people can't just, doesn't matter if we're talking the government can't just go in and take it and then all of a sudden not give you compensation. And they understood that this is what happened, and this is why they used the method that they did. Now, what needs to be understood is that this is where trial by jury becomes very important. And since we know that cases of $20 of damages are always going to be exceeded in pretty much every case, because, I mean, unless something's being taken or destroyed of less than $20, we're not going to see that. And when we're talking about such things as criminal cases, you're always going to see them put an actual value number well above $20 because of the criminal value of what they did, when we're talking violent crime as well. So when we talk about those, always go to trial by jury. And this is where we get to that. So it's always going to go to the jury, and it becomes something where, as long as they're not being manipulated by a judge, they're always going to be much better than a single judge. I mean, this is something why they established this, was to essentially copy what they were doing with the idea of the legislative bodies, was essentially to copy the same idea, and that's why they wanted this. They wanted to essentially create the judicial style of what they were copying on the whole idea of the legislative system. Thus, the idea of when they made a final decision on the judicial system, they wanted not just one person sitting at the top of the Supreme Court, but actually several people, so that they had to essentially argue it out. So it became a fight for the actual dominance of the actual opinion. And this is where we get to that. And since there was no set amount with it, this amount is actually changed at different points. Where you've had, obviously, during the Progressive era, you've had people trying to stack the courts for their advantage with it, and it's dropped back down during periods after that point to more reasonable levels. But it's always maintained this idea of people that were actually at this point to where they were not going to essentially be on this bias toward one position, one person making a decision. And this is something that you're really going to find throughout the Constitution itself and on these very important decisions. Because when you get to that, when you have one person making a decision, obviously they're going to do so, and it's going to be out of it could be so out of emotion. They're going to say so out of emotion, and it's going to make for a very bad argument. And if you look at the way the founders set up the whole system, it was to essentially make sure that that rational arguments were supposed to win over emotion, and emotion was supposed to be subsided on these things and essentially eliminated from these points. And this is why we see that when important decisions were being made, they were supposed to be made in these larger groups, so that you could eliminate emotion to the greatest detail, and that the most rational argument would tend to poke through as being the winning argument. Sometimes that works, sometimes it has not throughout time, but this is the actual theory behind it. And that's what we see with what on all these levels. This is why the executive was never given any power to go to war. Even though the executive is claimed so through powers that have basically been given to him through neglect of the judicial and the legislative bodies, but the executive actually has no ability to go to war on their own, nor commit any war acts, despite what the executive wants to state. This is the same idea with this. Is the idea with it is to actually keep important decisions out of the hands of one person making the final call, and that's why you don't want to essentially have one person making the final call and one person leading these situations, because you're dealing with people's lives and impact them to a great deal. And the idea of government is to essentially have the least impact on people's lives, and that's the way government's supposed to work. The idea is just to sort through these issues with the least amount of permanent damage to people's lives from the government itself, and to sort through these issues very, very smoothly. And that's why you're dealing with a jury of your peers, and trying to get this done with those jury of the peers. Now, if you like this, like, subscribe, click the notification bell, share us all the way on social media. Make sure everybody sees it. Make sure they can get recommended to subscribe to my page. Make sure you subscribe to my page, and if you haven't yet, look down below, because you'll probably see a link to my Patreon. Please consider donating to it at the address I mentioned at the beginning with it of the video, sorry. And you can donate between $1 to $100 or more a month, and it would really, really help me out, as I'm on disability. I'm trying to run this thing virtually for free, and I do need to make an income. It's really, really hard to do this because on disability you don't get enough money to actually have an actual income to live on, and I really want to be able to have that so I can actually have an income I can live on. Thank you, everyone. Bye.